case briefs, and so much more. LSData's got what you're looking for.
In a compelling turn of legal events, the United States Court of Appeals for the Ninth Circuit found itself untangling a convoluted case focused on tax liability from lease agreements in 1959. The court set out to discern how the substance of these contracts played out in reality, as opposed to merely focusing on the legal jargon written on paper. Caught in a web of fiscal intrigue were Gross Manufacturing Company and Automatic Sprinklers of the Pacific, Inc., who found themselves embroiled in a lease for a fire sprinkler system. The agreement offered renewal possibilities for 5 years at a stunningly meager rental of $32 per annum, devoid of any further expositions about the fate of the system after its initial decade tenure. However, the plot thickened when the tax court pierced through the haze of ambiguity laced in the contract, ruling that rental payments were not fully exempt from taxation and thus inevitably thrusting depreciation into the equation. The climax rested in the court's unflinching stance on emphasizing the practical outcomes and repercussions of the lease above its mere formal description. Despite the earlier ruling, surprisingly, the appellate court decided to revisit the case, urging the tax court to reevaluate potential deductions based on interest for the lessee. The court, guarded in its impartiality, acknowledged the commissioner's treasurer duties but subtly hinted on the sheer futility of pursuing multiple leases in light of the modest revenues they could potentially generate. As the legal narrative came full circle, the prior ruling was turned on its head. The court mandated new proceedings that adhere to its own interpretations and suggestions, thus marking an unexpected twist in this enticing legal saga.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.